Good morning. Good morning. Hello, my friends. How is everybody today? My name is Debbie. Welcome to my channel. We are on I forgot again, day 32, I think, of the Karen Read retrial. We missed maybe the last half hour, 45 minutes yesterday, because StreamYard was not having it. It just was not having it. Not only did it refuse to reload and refuse to work, it froze my whole computer. Nothing was responding. Absolutely nothing. And it was the weirdest thing because I was still live. I could talk to you guys through the mic. You could type back to me. But it wouldn't even let me put myself on the stage. And I was like, wait, I can't even see myself. Like, can you guys still hear me? And you guys were like, yeah. It's like, this is bizarre. I don't know what's going on here. So I was just like, okay, guys, well, I'll see you tomorrow. And then last night after Travis got home, I told him what happened. And I'm like, I might still be live right now. I don't know. And he goes, oh my gosh, I hope they can't hear us. I don't think they can, honey. The computer's off now. I think it timed out or whatever. We can't still be live. It's fine. But I cleared my cache and my cookies and everything, and so hopefully it's going to do better today. The charging conference starts at 10, I've been told. The defense did rest, so we're going to watch the rest. I think I've got it set to start, I think, at the beginning of the redirect, because I'm not sure where we left off, but that's a good place to start back at. So, a charging conference is a meeting between a judge and the lawyers for the purpose of developing a jury charge. They are held after the parties have closed their cases and before the jury is charged. Matters to be included in jury instructions are decided during a charge conference. It gives the lawyers an opportunity to put forth the objections they may have with regard to the instructions. And in most cases, it's very boring. In this case, though, I think there might be some fireworks, so I'm kind of really looking forward to it this time. But knowing Bev, she might not let the fireworks happen. She might just be, no, we're going to do it this way. It's easier this way. We're going to do it this way. Turtle Boy trial is going into an unexpected third day today. The prosecution has not rested. Bradel said he has 4 to 5 witnesses to present. This may go into next week. Oh my gosh. That's crazy. Terry said, and hopefully she doesn't make last-minute changes while reading the instructions like she did last time. From your keyboard to God's ears, Terry. That made me so mad. She said a perfectly good curative, and then 30 seconds later completely changed it to where it was garbage. It's like, seriously, woman.
You were asked about a fender vault collision, and you said, well, this wasn't a fender vault, right?
Correct.
What is a fender vault?
Okay, this is where we started having. So if there's a big chunk that you guys heard and you want me to go forward, just tell me. But I was too busy trying to put out fires. I missed a lot. So I would really like to start here. But if you guys have any objections, just let me know and we'll fast forward.
A fender vault is when you're hit by the front of a car and you're moving across the car. So you're moving across the center towards the driver's side of the car and the car hits you, you go up over the car and you fly over the fender to the driver. You vault over top of the fender.
Dr. Richler, where is my, as I stand here, where is my center of mass?
Right about your belly button.
Right there.
Yes.
So what would happen if I was hit by a vehicle, front collision, and the vehicle struck me below my center of mass?
It's going to flip you. Your center of mass will go, you go right up. If it was coming right at you and hit you, you'd hit it or over the top of the car.
Is that what's described in the industry as a fender vault?
That is part of a fender vault, yes, but it's at an angle. So instead of going direct back, it's because if the person's walking across and you get hit, you fly kind of back and over the top of the fender.
Did that set of circumstances, physics, have anything to do with in this case?
Well, none of the car is complete front to back of you.
F is it? Well, actually, you were at both test E and test F. Test E being the 24-mile-an-hour impact to the right arm of Randy, correct?
Correct.
And test F, the full rear impact, center of mass impact, correct?
Correct.
You were shown several photographs, exhibits of very tiny, tiny shards. Do you remember that?
I do, yes.
I'll get to that in a second. You're also shown some photographs of plastic or Fairview, clear plastic, piece of red plastic, correct?
That's correct, yes.
In your review of all the data in this case, do you know when those pieces of plastic got to 34 Fairview?
I do not. No.
Do you know how those pieces of plastic got to 34 Fairview?
I do not know.
Do you know who put those pieces of plastic at 34 Fairview?
I do not.
Were you aware in your review of the police reports that none of the plastic that you were shown was found at the time John O'Keefe's body was discovered and the area was initially searched?
That is correct, yes. I was aware of that.
You indicated that the cut on Mr. O'Keefe's nose, the right side of his nose, was inconsistent with coming from a vehicle, correct?
Correct.
Can you describe why you came to that conclusion?
Well, if you're standing at the back corner of the vehicle and it strikes the arm, and let's be clear, if nobody wants to say where the arm was or how it was positioned, if they're claiming the abrasions are a result of the fractured taillight, it has to strike the arm. You have to be standing like this. The debris goes forward with the vehicle. So it's with your arm like this, it already passes by the person. And if there would be any contact whatsoever, it would be with the right side of the face. The shard can't go on the left side of the nose. That's entirely inconsistent with the fracture and how the glass and the cover would actually move.
Dr. Richler, you were asked a series of questions about a hat. Do you remember that?
I do.
About some shards of plastic material, correct?
Yes.
About a drinking glass.
Yeah.
If there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Well, because if there wasn't a collision, it wasn't that debris or those items weren't a result of that impact. You can explain how that got there, I believe, easier than if you can't explain how the impact occurred. If the injuries don't match up, if you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened. Scientifically, it makes no sense.
Scientifically, is the first question that has to be answered is, was there a collision?
Objection.
Sustained, you have to watch the formal question.
Of course. In your expert opinion, based on all of your review of all of the data in this case, all of the testing that you've undertaken, do you have an opinion as to whether or not there was a collision with John O'Keefe?
I do.
Objection.
Your Honor, I object
And why is that, Mr. Reed?
because it's devastating to my case.
Overruled.
Good call.
I'm sustaining that, Your Honor.
In your view, was there evidence of a collision with John O'Keefe?
Objection.
Sustained.
In your opinion, were any of the injuries that you saw suffered by John O'Keefe consistent with having been struck by the subject Lexus?
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do.
Thank you.
Doctor, you just said that you do not believe that there was a fender vault collision. Could it have been a clip?
Could it have clipped Mr. O'Keefe?
Yes. Not hit him, but clipped him.
Well, I don't believe that's consistent with the evidence and what occurred. I mean, someone can get clipped by a car, sure, but in this case, no, I don't believe the evidence indicates that's what occurred.
The glass. When you learned of the information of the glass in Mr. O'Keefe's nose, when do you think it was that glass was pulled from his nose? What date?
I think it was the morning when his body was discovered.
January 29, 2022?
Yes, sir.
Somewhere around 6:15 a.m. Is that your understanding?
Sometime when his body was discovered. That's correct.
Do you know or understand that, did you see any evidence that Mr. O'Keefe had a drinking glass outside of 34 Fairview Road that morning after he got out of the defendant's Lexus? Do you understand that?
What do you mean evidence?
Drinking glass. Did you hear anything about that in your review about?
What evidence would there be? Is there a video or a photograph, you mean, of him holding a drinking glass? Because otherwise there's a drinking glass there, but there's no evidence that he had it.
We have a clip, right? Okay. Judge, can I come sidebar?
Okay.
Yeah, evidence, Hank. You know that little pesky thing, evidence you have to prove stuff? That evidence. You don't just get up there
Up
and
at them,
say,
and they didn't up at them, and they didn't flinch.
you know, that thing?
Abrasions, and then a half centimeter.
And there was a snowblower or a
You know that thing you have to have that proves that stuff happened? You know, you can't just get up there and say, you know, this happened, right? Got to have evidence.
see the confined area. See the confined area in which. And the snowblower.
Hey. Okay, I'm leaving it.
You were asked about whether or not any plastic taillight shards were found near Mr. O'Keefe's body. Do you know the limits of the search that the Canton Police Department did around Mr. O'Keefe's body, how small of an area they searched when they first went there?
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And did you see the confined area in which that happened?
Well, I mean, I saw the area where he was blowing with the leaf blower.
Have you seen any information or evidence whatsoever that the pieces of taillight that were found after that search, have you seen any evidence that they were found in that exact area, or were they found in different areas on the lot?
I'd have to go back and look. I don't recall specifically.
And so when there was a snow blower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
If it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Did you notice in the injuries to Mr. O'Keefe, most of them are on the right side of his body?
Well, we have the abrasions and then a half centimeter abrasion. And then we have the laceration and scuff on the left side. And then the skull fracture, it's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the half centimeter. It's not a bruise. It's a half centimeter abrasions, about an eighth of an inch.
When you're conducting an investigation or you're doing your analysis and you keep saying the physics and the physics, do you add a little bit of common sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics. It's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of a smell test, bigger picture. That doesn't make sense. But the physics, you can't deny.
Terry is on fire today.
It. You have to accept what science tells you.
Can't deny it. That's the line you were laughing about in the documentary as one of your answers that you were all celebrating.
Objection.
Isn't it?
The objection sustained.
How'd that taillight break, sir? How'd it break that night?
How did? Oh, I don't know. There's no evidence of how it broke.
I have no further questions.
All right, you're all set, Dr. Wenchler.
Thank you, Your Honor.
Is there an objection? So, subject to us discussing it. Mr. Jackson? Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay. They've been marked for identity. Jurors, I'm going to see counsel for a couple of minutes over here.
Court's back in session. You may be seated.
All right, so I had a minute to look at the PowerPoint. Are you in agreement on the PowerPoint?
We're not. I do not want to admit it. I don't think it's substantive evidence.
Okay. Mr. Jackson?
Exactly the substance of this. Dr. Welch's argument.
Which was not objected to, right? But did he object to the PowerPoint coming in?
It's been well under pressure. I don't know what Mr. Lesson's given to do with regard to PowerPoint. That's the question. The question is whether this PowerPoint is admissible, and it is. There's nothing in it. We take out all hearsay, discussion any feelings or thoughts, thought processes. These are all the tests that were completed and done, exactly as Dr. Wilkes' PowerPoint was done. Dr. Wilkes' PowerPoint is in evidence. This PowerPoint should be in evidence.
Is there anything in this PowerPoint by way of videos that is not already in through Dr. Wolf?
I believe the video of, the video in Dr. Welch's PowerPoint, there are, most of the videos are included, no, I'm wrong. Things have slowed down. So there are, the videos are the same, but the videos that Dr. Renshaw used because of the side of the case that he was handling, the
Why
biomechanics
in
side of the case
court?
that he was handling, slowed down significantly to show the deformation of the arm, the force impact on the elbow, the hand, forearm, about which he testified. So what he did, and I remember asking him this before I ever saw the PowerPoint, is there going to be anything different? He said, I use the slow motion cameras more than Dr. Wolf does because I need it.
Okay, so I need you to tell me tomorrow which slides specifically answer that question for me. Okay, whether they're in evidence or not, and which ones are not regarding the videos.
Is the suggesting that it's not going to let just the entire PowerPoint?
Maybe. I'm going to take a look at it. There's an objection before me now,
I realize that.
so I have to rule on the objection. So I will take a look at this, okay?
Okay.
So if you let me know, and if you want to let me know tonight, I can let you know first thing tomorrow. All right.
Have you heard briefly?
Yes,
Very briefly.
yes.
I am objecting. It's not admissible. It's hearsay. It's a strategic decision. The past introductions have been strategic. The defense did not object to Dr. Welchers. I did not object to Dr. Wolf's, but that was a strategic decision. I'm objecting.
Okay,
The defense objected to Shannon Burgess. Only a select amount of documents were allowed. I wanted the whole thing in. I was precluded properly from introducing it because it was hearsay and they objected. I'm objecting.
okay.
There's no hearsay. They objected to certain slides. We took out the slides. If they had an objection to the PowerPoint, they should have posed that objection before it was displayed for the jury.
Well,
We've not seen the entire PowerPoint. I think it's tactical. It's not strategic. It's tactical. They just don't like it because it hurts the case. If they didn't want to think certain things before the jury, which is exactly what admitting it into evidence does, brings it before the jury so that they can see it, they should have objected in a timely manner. When they objected, they chose certain slides, certain data on certain slides, and we took all of that out at their request and at the court's instruction. We did that with the court's instruction, with the Commonwealth's instruction, and there was no objection to playing before the jury. Given the fact that it's been displayed in, not in part, in whole, as it now assists for the jury, assists for the court, for quadruple K for identification, it should be admitted.
okay.
Just like Shannon Burgess. It's no different.
All right.
In evidence.
So, Mr. Jackson, you left slides and you want to put in evidence, the videos, just the videos. Let me know that, and if need be, I'll hear you all on this tomorrow morning as well. Okay. All right. Is that it for today? Will we see everybody just tomorrow morning? What else do?
Mr. Lesson needs to, I didn't mean to interrupt.
We should get here for Brennan first.
After the defendant rests, we will not be calling any witness, putting on any further evidence.
Okay. All right.
Your Honor, it's late in the day. We would like to renew our motion to require finding not guilty after the close of all evidence. It won't be a lengthy argument, but I'm happy to be heard on that in the morning if the court prefers we got tomorrow morning.
Okay. Is that all we have left now? I have no idea what Mr. Alessi wants to talk about, but would
I'd like to respond to that, Your Honor, and the answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
okay, great. So,
The technical thing is we need to move in the 3 items of evidence, the documents associated with the sweatshirt. I think they've been marked for identification.
no, they were marked as evidence, right?
They're trying to mark as exhibits.
Yeah, they're exhibits.
But no, they're come into evidence. Your Honor, I mean, ruling this.
Are they,
I thought They're marked as identification, not evidence. If they're an evidence, they're in. If it's identification.
So I need to find that. It would be my intention that they get put into evidence. I'm not going to display them and bring a jury in just to see those at this point.
I'm not asking for that.
Okay.
As long as they're in evidence and I can use them in closing argument, then so be it.
If I can for clarity, Your Honor, there are exhibits, I have YYY.
So that's not an exhibit, Mr. Alessi, if that's how it marked. That's identification.
I have a different parlance, I'll use this word, parlance. Yes, it's YYY, ZZZ, AAA, BBB. There's
So that means that, all right, so that's for identification. Letters are identification, numbers are exhibits.
Your Honor, I understand that. We all know what we're talking about, and Your Honor agreed that they're going to be in
Oh,
evidence.
Alessi.
So, and I've ruled that they're in
Illegal.
evidence. I just need to know for this record whether they're in evidence or not. What you tell me, you just told me they're in evidence. They're not. They're exhibits. They're identification. Now they will become exhibits. Can we do that now? Do we have them?
It better become exhibits, woman.
Where are they? Oh, Jim, they're in there? Okay.
Yeah, and Your Honor, my whole point in wanting to be heard is that they're not in evidence, and I want to make sure they get it. That's my point.
Yeah, woman. They better be. Don't make me come to
What number
Massachusetts.
are we at, Madam Court Reporter?
Is it 230?
Okay, and we'll do A, B, C, D.
So is it Y, Z, A, and B? I think I have those. I don't think I have those. Counsel, I'm not sure I have those.
All right, so
You
we
better,
will make,
Jim.
so as of now, they're in evidence. Tomorrow, we need to physically put the sticker on those.
Can I stick numbers before we read these?
Yes.
230A,
I'm sorry, say that one more time.
230A through C. 230C.
All right.
Council, there are four,
Affordable aid.
A through D.
Just so the record, this is limited in saying different things. They were marked for identification as triple Y, triple Z, quadruple A, and quadruple B.
Okay.
And all I need to do for my records is figure out which one is which in terms of the whole court's marking. As soon as we do that, I'm good and I'll get out of here.
We will do that first thing tomorrow morning.
That's fine.
Right? We will, so everyone is in agreement then. I will let you have tomorrow without the jury. We'll have our charge conference here in person. Then I'll give you the rest of the day to get your closing arguments ready. I'm imagining that you don't want to argue tomorrow morning at 9:00. Is that fair?
That's fair.
Mr. Brennan, are you in agreement?
I'm in agreement. I'm not interested in arguing.
Okay. All right. So we'll give you tomorrow. We'll have a charge conference tomorrow. I'm going to ask the court officers to call the jurors tonight as soon as possible. This is great that you did it. I was going to give you until 7:00 tonight, but if you're certain, then the court officers will call the jurors now and let them know they don't have to come in tomorrow. And then when they come in Friday morning at 9:00, we'll do arguments and charge. Tomorrow morning will be the charge conference. Since we don't have jurors, do you?
Wiggles, you left early yesterday. StreamYard took a dump on me yesterday. So we're watching the rest of what we missed yesterday, which is what, like a half hour, guys, maybe? So this is the very end of yesterday's stream. And they're going to start the charging conference, which is where they go over the jury instructions. They're going to do that this morning. And that's probably all they're going to do today. And then tomorrow is going to be closing arguments. So we're going to have a short day today.
I want to come in at 10:00 instead of 9:00.
That would be great.
Does that work for the Commonwealth as well?
Yes.
Okay. So I'll see everybody tomorrow morning at 10 for for the charge con. Do you have them now, Jim?
I do, Judge. And just for the record, YYY, ZZZ, AAAA, and BBBB are 223A through D. If you want to look.
In the same corresponding order. So you know what they are, Mr. Jackson, in order. Okay.
223.
223.
Thank you. My only other question, Your Honor, was regarding the parameters for the argument. Last year, we were relegated to 1 hour. I would ask.
Just let this pass. No, I got it, but yeah, you can go.
I would ask. I would ask for an hour and a half for a final summation, given the gravity of the case, the length of the case, the amount of evidence that's been adduced. I think that's outrageous. I think the court normally allows only an hour.
You might get an hour and 15 minutes out of me. Let me see about an hour. Let me see. You would not have got an hour and a half by asking for 2 hours. Mr. Brennan, what are you looking for? Do you want?
I don't have a position. I'll take whatever the defense gets.
Let me think about it.
Oh, her
All
little
right,
lapdog.
So we will see.
I'll take whatever
All right,
I
so I'll see
get.
everybody at 10 o'clock tomorrow morning. Is there anything else we need to discuss?
No, thank you, Your
All
Honor.
right, we'll see you tomorrow morning.
All rise for court, please.
Okay, let's see if I can find today's stream. What is going on? Nothing. Nothing is going on. Just a fan. Ah. Out.
You are unmuted.
Somewhere.
Was now open, you may be seated.
Good morning, Your Honor. May I call the case?
Please.
For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present, the jury is not present, the matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Ms. McLaughlin.
I'm Malik Muhammad. Morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Morning, Your Honor, Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti from Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti, Mr. Alessi, you're standing in also for Mr. Little?
We are, Your Honor.
All right, so first thing we left off yesterday
Wait,
was
wait,
whether
What?
KKKK for identification, the
No, I
PowerPoint
wanted them there. I wanted
of
fireworks.
Dr. Rentschler would be entered into evidence. It will
Damn
not
it.
be based on the evidence, so it is excluded from evidence. So it's marked still
What?
for identification, and you're saved on that.
What's
So we ready to
excluded?
go with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for the required finding of the all the evidence.
So, no, we can do that now. So now that my rules ruling is on this. Evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit have destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death. A dog which mysteriously was absent from the home at 6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept. A dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Russell, that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were three additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sally Port, the taillight was merely cracked. When he was shown photos of what it looked like in the Sally Port after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins. The same Brian that month, the same Brian whom Karen ghosted a couple days, January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Alberts who is on video, hot, angry.
You just said Albert, you mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian Higgins, who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on 3 indictments.
Lally. Ooh.
Thank you, Your Honor. Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples when it came to Officer Barros. His testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that Ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. La Posada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop, of course, of his plow duties on that particular early morning as well. And as the court could see from the cruiser camera video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There's been nothing presented in the defendant's case to diminish, particularly to the standard in the light most favorable to the Commonwealth, and request that the defendant's motion be denied.
So, Mr. Yannetti, you know I have to view this in the light most favorable to the Commonwealth.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied.
Thank you, Your Honor.
Okay. All right. So regarding the charge, So we'll start with the defense missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw 2 of our requested instructions, which would shorten things today. I think it's,
Oh, okay. So everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction. You're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right. You filed, I saw it in email. I don't have a hard copy of it.
That's Mr. Molesky's motion.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're gonna go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions, and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand the court's position might be on this, but as far as the instruction related to murder charge, Commonwealth is only seeking instruction on murder crime.
All right, so we will deal with that. I'm going to go through the defendant's instructions or sort of the general instructions first, so it's probably easier to go through those. And then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction to propose on page 4, reaching a verdict. I will make it crystal clear, though. I think it was, and I was upheld on it. So I will make it crystal clear. Okay. So I'll give you that, Ms. Giannetti. This what is evidence. I probably won't.
Well, Caitlin was at the
verbatim
house.
what you have. I'll take a look at it.
I mean,
will
not
certainly
Caitlin.
cover all these
Yeah.
topics. So Ms. Giannetti,
Yeah,
you're telling me that
Caitlin.
your client wants me to give a defendant.
Wasn't Caitlin at the house? So Caitlin took the dog home with her when she left. Right? I don't know. Maybe Allie took it. I thought Caitlin just took the dog home with her. Maybe. I don't know. But yeah, the dog wasn't there that morning whenever Jen went in the house because it was already gone.
Did not testify instruction.
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again. with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay.
No.
Go ahead. Do you want to make an argument?
How you
Just
why?
Your Honor, when it comes to the vote, and I would incorporate, I know the request for instruction, third-party culprit that counsel be prohibited from making a third-party culprit or voting argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the Commonwealth, the defense should be allowed to make a Bowden to
No.
argue Bowden?
Bowden.
I would submit, Your Honor, that the entirety of any testimony or evidence related to either vote or third-party culprit in this trial has come from questions from the defense, not from actual evidence in the
3 words, dude. Red Solo Cup. Are you kidding me? Yes, they can make a Bowden defense.
That it was put into evidence or anything of the like. So in the instruction and the arguments are based or predicated in the case law evidence. Not, and obviously, as the court is well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth was fixed, if the court looks at what is actually in evidence, there's no basis whatsoever for not only a vote or third party instruction, but specifically for even counsel to make arguments during the course of voting. And I understand voting a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a close look at it. Mr.
No,
Giannetti,
you
what is
disagree.
the
You
Bowden
don't need
evidence
to take a
argument?
closer look.
I
Woman.
think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate evidence. Chain of custody was up to the investigator, failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the solution of everybody else. It was not an investigation. Day one, it was focused on one person and one person only. And just responding briefly to Mr. Lowry's comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor. We motioned and renewed it, asking for reconsideration of the court's ruling that to say that we didn't introduce that evidence when we tried to do it.
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And so I think that's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know. But tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did it.
Okay, so just so that it's clear, that you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. I did say that I would give you the opportunity to give testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Higgins or Brian Albert committed or had the motive and all of that, not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay?
Yeah, I understand. That's what I was looking
Okay.
And that's really that was the clarification.
Yeah. So Mr. Yannetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
We're on page 8. I just want to almost have an objection.
Yeah, check mark next to recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. You know, obviously, it's not the strongest DQ argument that we would have not occur at police station, but, you know, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on their own cell phone. It wasn't done. We had to rely on police memory of what my client said today was a possibility for a recording. So I think there's an argument that it was a custodial interrogation. You know, we had police officers who, you know, refused to sit down in the living room. They were surrounded with her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr.
And
Hill?
I would also add, Your Honor,
Sure.
they did seize her vehicle at around stand. So, you know, that it goes to the issue of custody and my client being able to deny it.
All right, what do you say?
That's the very nature of the objection, Your Honor, is there could be non-litigation nature about this. So the trooper spoke to disagree.
Okay, can you hear me now? What did I do? Sorry, guys. My cousin's having a crisis. The one that just had back surgery. She's in that, you know, the depression. Oh, I don't know if you guys know, but when you have surgery, you're like excited at first because they're going to fix what's wrong. And then you hurt so bad that after about the first week, you think you're never going to be out of pain because the pain is always worse before it gets better. And then you get in this like depression where you think you're just going to feel like hell for the rest of your life. That's where she is now. So I'm sorry, I didn't catch it fast. I didn't catch it fast enough, but I have a depressed cousin that needs to be cheered up. I'm so sorry.
They did seize her vehicle around the same time. So
Horrible because they're not talking into microphones, and I don't know why. And I'm not sure we're at the right spot. I think we are.
the issue of custody and my client being able to deny it.
All right. What do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the juror spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, over the course of that. They spoke to her while she was seated on the couch in her parents' living room. The parents were present, no one was restricted from eating. And it did not end in custody. Your cell phone and on that day ago. But I don't think that transforms that conversation or interview in a parent's living room into a custodial interrogation. The bigger issue that I have placement, as far as there's already been within saying requested jury instructions or requested jury practice, and then following the DG and Batista language in the defendant's requested jury instructions, there goes on to all of this other requests regarding your compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context between practice. I don't think it's something that should be highlighted in two different sections. I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she's speaking with Sergeant Lieutenant and have this testimony from the stand, that initially she said she wanted to be fine with answering questions, but didn't want to get into any details. And then when the questions became centered on, more centered on details, at that point, and I know that's not evidence to the jury, but of course, well aware, she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview. And I don't think that arises to the level of abuse.
I don't care.
I would ask basically that everything on page 8 prior to
Care if she was in custody or not. If you're questioning a witness, I think it should be recorded. Cops, traffic cops, patrol cops, whatever, they all wear body cams. So their interactions with the public can be recorded. If you're interviewing people that are potential suspects in a murder, how much more important is it that you record that interview? Because they did it at her home or her parents' home rather than at a police station, they don't have to record it. That's stupid. I think because detectives don't have to wear body cams apparently, so they don't have to record it because it was done at her house. Everyone, like you said, everybody has a cell phone now. Whip out the cell phone and record it. At least you can record the video, the audio, if nothing else, with your cell phone.
All right. I'll take another look at this and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that does not apply to the after residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
Yeah, I was just gonna say that because she was Baker Act or not Baker. They don't have Baker Act up there. 5150, whatever it's called. Section, whatever they
Prior
call it.
statements. I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn. So is the.
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We asked the court to repeat that one sentence.
Okay, so I did not see this when I took a quick look at the view. All right, I'm not going to repeat it.
Beverly.
All right, lost or destroyed evidence you're withdrawing. Direct and indirect evidence. I try and give a shorter instruction on that. So I will, even the one I gave.
Beverly, do you remember what happened last time because of your instructions trying to make it shorter and easier? It was more confusing. Your easier is more confusing. Remember that this time.
A period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think. On that, I'll include that
Yes,
somewhere in it.
Carla. I think one of the biggest reasons, this is just my supposition, but I think probably because of the fact that Dr. Welcher said there was no x-rays. And then they busted out all these x-rays after he got off the stand. So I imagine, what is my laptop doing? Crazy things. So I imagine that Brendan doesn't want to bring Dr. Welcher back so the defense can get up there and say, why did you say there were no x-rays? And something else that was said that wasn't true. I don't remember now what it was. I'm sure Judy does.
That's what a police officer or someone else works for law enforcement.
Oh, what do you mean by that?
StreamYard. Knock it off.
We're not.
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that. Do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics. What page you on? Okay.
One suggestion there was indicates Commonwealth has introduced photographs and evidence. I would submit.
Yeah, I'm just.
I actually think that defense has introduced more graphic.
Yeah, so I would just say you've seen photographs. Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it. So I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally. So let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence, evaluating the evidence, there's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors sort of made to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, not or, solely because of that juror's occupation, education, experience, or any other characteristic? Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks.
Okay.
And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? Well, that the attorneys, and I may say if you find or something, preface it. Witnesses when the attorneys interviewed witnesses when preparing for and during the course of the trial. You may not draw any favorable inferences. There's nothing improper about news. On the contrary, prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in, I don't know if we include that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction where that came in. I also gave the state of mind being known by the defendant and the likelihood that she would act. So Commonwealth versus Binns in those cases.
You're right, we're looking to Aruba. We don't believe that there was really any testimony that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee.
It came in through
She
text
testified.
messages. Oh, we didn't hear Kelly's testimony because she's a minor. It
All
came
right,
in through
so
text messages too,
did I
though.
give it any other time that
It came
there's
in
an
through,
event that I
I'm
should
talking to
highlight?
her like she can hear me.
I don't
It came,
I
it
don't
came in through Brian
think
Nickens'
so.
text messages. It came in through Karen and Brian's text messages.
All right. I think I have to add that here. So electronic communications instructions. So I will think about that. All right, those were the limiting instructions I wanted to. All right, I'm consciousness of guilt. Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
No, so the only,
1 second, let me just pull that up. Okay.
Your Honor, follow question clearly not for any change or alteration in the instructions that were given, other than there are three-pronged analysis, and essentially the Commonwealth is requesting is that the jury be instructed
Speak up.
merely on third-pronged analysis. That's the only one that really applies to these factors.
Okay.
The Commonwealth here, the first two prongs are essentially extraneous. Avoid confusion.
Do you have supportive case law for me to single this out? What do you say, Ms. Giannetti? Say what?
He stated alleging that she it was her national lightning arts quote. I just don't know, going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue.
No, you're not, Judy.
We wouldn't have an objection.
Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
And you're right, before the court makes a decision on that, we see what the court is proposing if you are going to alter.
If I alter it, it means I remove those two. That's all.
Right, no, we just want.
Sure, sure. My guess is that won't happen, but we can see. All right. So, lesser included offenses. Did you want an OUI instruction? You were.
We're asking for that.
Okay. All right. Right, I think that's it, aside from Mr. Lessie's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court on behalf of the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's ruling.
Okay,
But it wasn't in final form. We believe it's in final form now.
and you all agree that it's in final form?
Well, they haven't seen it.
Oh,
But I'm going to
okay.
give it to them now. Can I hand this to the court?
Sure, thank you. All right, so.
The only other issue, Your Honor, is we do have a.
Hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it. So
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
Okay.
Just a couple other things before we get to Mr. Valesky.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence from.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't.
We have to redact it, so these
Okay.
are redacted. It's on a drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then, will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count two, Your Honor, if I didn't.
You did not.
Okay, we do have one, we've got given a copy to the Commonwealth, can I hand the
Okay.
proposed copy to the court?
Sure. Is it the same as last year's, but now with a?
It's different.
Okay. All right.
You'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually in that.
Yanetti, jeez, I'm sorry.
So, Your Honor, you'll recall, we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser included and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged.
Here we go again.
If it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense. And again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty. We've also changed a little bit of the wording, you'll see, which makes it clearer and less confusing.
She's done that this whole trial.
The jury is given.
She's called people by the wrong name this whole trial. This whole trial. She called Carrie Roberts Jen McCabe. She called, I don't remember, somebody else by the wrong name. She's gotten everybody called by the wrong name. Not everybody, literally, but she's called a lot of people by the wrong name.
Options for theories of guilt on at least like three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clear, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports it, the defense requests it, that the court must get it. Having said that, the verdict slip that was used in this matter last year, the Commonwealth submitted is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if you're aware, there was a case recently, while this case was going on, tried before Judge Lowell, in which he had similar issues. I believe he was at least part of the verdict slip from the first trial, in this case, as sort of template for the lesser included to be instructed and the verdict slip that they utilized in that case. I don't have a copy of it on me, but I can certainly get the court copy of it. But that may be somewhat helpful with the court's opinion.
Okay, was that on murder case?
It was not, but it had to do with felony motive homicide.
Yeah, I'll take a look at it.
Mr. Turk.
Mr. Turk. Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lowell is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're.
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it up.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering. Okay,
Do you need an extra copy?
sure. Yes. Or, you know what, just mark it for identification, Margaret. We'll do that.
Case is driving
Kristen,
her
please.
crazy.
Just for ID.
It's LLLL Friday.
Thank you. Mr. Lally.
Your Honor, just one request, circling back to the constitutional instructions. So Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference to the arguments of the jury related to specific areas which we would need conditional approval before we did this. So the two areas that are sort of listed within that we would like to make some argument to the jury regarding is the defendant's taking of the Lexus from one mental that came to her parents' residence indictment, and then certain statements made in reference to various clips of the way of her statements. In particular, would be the one where essentially she says that it came to her.
All right. Mr. Yannetti, do you want to weigh in on that?
Yes, we can object to that. I don't see. Her or me being evidence of consciousness of guilt. And she's brought parents' house.
There's a baby crying.
Obviously,
Its name is Spike.
in fact, when the police called, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other clues to say.
Yes, so I did want to ask you though, Mr. Yannetti, I think it's an argument that can certainly be made regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well? I just wanted to give you the opportunity. Okay.
It's my baby.
Anything else? Anything else, Mr. Yannetti? We're going to hear from Mr. Alessi, but
does not object to the reduction.
that's great. Thank you. One less thing you all have to do today. Okay. I know. All right, so let's make that new redacted with the exhibit what it was before. Excuse me. The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
Right, this is the testimony that came in.
Of Proctor, I was, yes. All right, so we'll find the exhibit number and we'll just, 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need a Commonwealth?
No, I wrote on it. I need the Commonwealth's.
This is a clean copy.
So that will now be 209 in evidence. You know what? Can we make that 209A? We need, Ms. Gianetti, we need to keep record of the first one that was not redacted. So any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
So what do you think? Yeah.
I-
Yeah, so we'll switch it back to ID and this will just be 209. All right, did we have an ID number on it originally? Can it still be that?
Is it actually NNN? Or is it, no, it can say that.
Okay.
Right? 'Cause this is the-
Oh, it's just NNN. It's not,
Well, where did it?
no, it became 209.
So that has to be-
Our thinking is it needs to be sent back to letters for ID.
Yeah.
So it'll be marked MM for ID.
That's great.
Perfect. And then the redacted version will now just.
209.
Yes.
Yep.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Lessie, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I spoke with the Commonwealth about what the topic is.
Trust me, those squeaks get annoying. The both of them, neither one knows what the word no means. And I know they're animals and it's instinctual but can't you treat animals? I mean, train animals like you can train them. They know what the word no means, right? Like, is it my fault? Have I just spoiled them so rotten that they just can't take no for an answer now? Because Belle does the bark, he does the little whine thing, and I can't say no to either one of them now. Well, actually, I did say no to Belle a while ago. She wanted another cookie. She finally gave up and went back to bed. But they do the puppy dog eyes and they bark and they whine, and I can't. They're too cute.
It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of. That's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally can state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
So Your Honor, the Commonwealth's position is ultimately for the court as far as whether or not it's appropriate instruction to give in the final charge. What the Commonwealth will submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the final charge.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Leslie.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt. The subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end undisputed. Now let's back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe it's what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, During the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't.
This is not an official transcript, right?
Exactly, Your Honor. So I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury therefore should not weigh and value his opinion. This is very significant, Your Honor. We didn't cause the problem of this issue. So to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error. To me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction,
is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there. Again, we believe that just the sentence at the end to take care of the harm to our witness with regard to what occurred. So therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally. Keep your voice up.
They objected as soon as they could. They objected as soon as they could.
Heated trial during the heat of the extended exchange with a witness on the stand. Things can happen. Basically, it was recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper.
No, they need to accentuate
it was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury. And furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed in the final charge.
Okay.
Yes.
So I'll consider it, Mr. Alessio.
Thank you, Your Honor.
Down and shut up.
Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least hopefully there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had, to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that.
Okay.
But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, not at all.
All right, so we'll see council in here no later than 8:30 tomorrow morning?
Sure.
We'll council here at 8:30. All right, thank you.
All rise for the court, please.
Is there already one of these? Like, are we swapping?
Okay.
Goodbye.
Okay. Tomorrow at 9 o'clock. Okay, that's it, guys. Can you believe it? Can you believe it? It's over. Well, it's almost over. We made it, guys. I don't know yet, Flash. I don't know what I'm going to do next. I'm thinking about taking a week off. But we have to do Phil too. So I don't know. I guess we'll figure it out when we get there. So still doing Phil Spector. I know she sent them home early a lot. Kept saying they were ahead of schedule. I don't know. She's so crazy. Like that one day that she said we were going to skip a day. And then the next day complained that, oh, I shouldn't let you skip a day. Didn't need to skip a day. Why did she want to skip a day? I have no idea. It makes no sense whatsoever. The Instagram trial? What's the Instagram trial? I haven't heard of that one. I don't know what we're going to do next. I'm tired. I don't get as tired when it's like shorter trials that are just like a week or two. But I got so sick of taking notes on this one. I was just like, I'm done. I'm just going to crochet the rest of the trial. Oh, man. So, and now I'm scared. Like, oh, I didn't hear about that. Oh, that's right. I am doing Coburger. Is that still in August? Well, that's over a month away. I don't think he's getting a new trial. Carla, we would have heard something by now. Yeah, I was going to do Coburger. I'm trying to from August to November. That's fine. I am purposefully not watching anything about Coburger because I don't want to have any preconceived notions. All I know is that 4 college kids in Idaho were killed. I know they found a knife sheath at the scene that had his DNA on it. and that he didn't live in Idaho. He lived somewhere else. I forgot now where that place was. And that he was a criminology major. I think that's all I know. So, and that's all I want to know. I also want to do Courtney Clinty, but I don't know when her trial is. They keep saying they're going to do it, and then they don't do it, and then I don't know what's going on with that. For a while, she was having hearings like boom, boom, boom. Brad Simpson. Somebody said something about Brad Simpson the other day, and I was like, who's Brad Simpson? I don't know anything about that one either. Since we don't have anything else to do today, Robbie's not here. Robbie, are you here? Robbie! Dang. I was going to say we could watch Proctor's testimony if you want to. But Robbie was the one that wanted to watch it. Well, she can watch on replay. It's still not the same, though. Replay's not the same as watching live. I said no. I said no. Oh, that's right. Neither is Jill. Jill's going to be back later. I don't know why Robbie's not here. Jill had to take her sister-in-law to the doctor again. Yeah, we should wait. The shaking thing that you do hurts, Mommy. Can you not? Can you please stop doing that? That new thing you're doing, I can't, Belle. I can't. It hurts me. Can you not do that, please? Oh, for crying out loud. She looks like she's about to have a seizure. She's just shaking like a leaf. Just can't. Louise Woodward. Why does that name sound familiar? $19.97 is vintage. Okay. Who's a horrible person? Oh, that case. I know that case. No. That's why I know her name. Nope. 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 That's why I know her name. Nope. Well, what can we do now? Jed Simpson was live a minute ago. Now I can't. There he is. Guys want to watch? Well, we can end this stream and do Spectre if you want to do that. Yeah, let's do that. I'll throw up a Spectre stream real quick and we'll do Spectre. Because it's still really early. So, yeah, let's do that. So, if you're not watching the Spectre trial with us, okay. All right, Flash, sleep well. So, since the charging conference is over, I knew it wouldn't take long. I thought it'd be longer than this, but so we're gonna cut this feed short, and I'm gonna make another feed for Phil Spector. So we're gonna do some more of that, and I will see you tomorrow for closing arguments. Oh, please, a trial's a trial. Okay. I will see you guys tomorrow for closing arguments and Karen Reed. Bye, guys. Have a good day.